Good morning. This is the second part of my brief series of talks about what has the EU got up its sleeve as regards commercial and maritime issues. Today I'm going to talk about the question of civil liability and artificial intelligence. And obviously, we in the shipping community have been very much aware of the prospect of unmanned vessels, autonomous vessels, coming on stream perhaps sometime over the next decade. And there's been a lot of discussion about potential regulatory and liability issues which this may pose. And indeed, the Institute of International Shipping and Trade Law has just recently published a monograph on these issues with the publisher Hart. So very much in our minds, it's also very much in the minds of the EU. They're reviewing the product liability directive. The European Commission has recently produced a proposed regulation to deal with the regulatory aspects of artificial intelligence within the Union. And then there's the question of civil liability. And that's what I want to speak to you about today. In October 2020, the European Union Parliament proposed a regulation, and it was going to have a strict liability regime for operators of high-risk operations. The only defence would be if the harm or damage was caused by force majeure, and due diligence would not be a defence. That's Article 2. And it was also then going to say that if you were operators of non-high-risk operations involving artificial intelligence, there would be a specific fault regime which could be laid down. But we're going to deal with the high-risk operations and the strict liability regime proposed first of all. Let's have a look at its scope. It applies on the territory of the Union. Now that is pretty wide. I mean, it's going to include the territorial seas of the coastal states of the Union. And we've seen from the Commune de Mesquite case with the operation of the Waste Directive, that certainly applied once the oil washed up on the shores of France. So there is a potential overlap here with maritime matters, and particularly maritime conventions on pollution. And that's one of the things which is slightly concerning about this proposed regulation. So on the territory of the Union, where a physical or virtual activity, device or process driven by an AI system, well, we're talking autonomous ships at mass levels 3 and 4 here, and it's caused harm or damage to the life, health, physical integrity of a natural person, and then to the property of a natural or legal person, or has caused significant material harm resulting in a verifiable economic loss. So a very wide scope here, and certainly something which could, if you have an autonomous ship which is breaks up, has an accident in the territorial seas of, say, France, and a whole lot of containers wash up, you're certainly going to get damage to property, you're certainly going to get material harm, significant harm, and a verifiable economic loss. So that could actually potentially come within the scope of the strict liability regime proposed in respect of a virtual activity, device, or process driven by an AI system. Now, it has a sort of savings provision. The regulation is without prejudice to any additional liability claims. So you can still bring extra claims resulting from contractual relationships. Okay, so that's the Hague and Hague-Bisbee rules saved. as well as from regulations on product liability, consumer protection, anti-discrimination, labour and environmental protection. Now, I'm presuming, well, what does it mean by regulations? Are we talking about, it's probably at least EU legislation, it's probably national regulations, but does it cover just straightforward tort claims? Doesn't say. And also, with the International Maritime Conventions, how easily do they fit into this regulations on product liability, consumer protection, anti-discrimination, labour and environmental protection? Well, I think for things like the CLC, you would certainly come in under environmental protection. Things like collisions, the Brussels Convention of 1910, well, you know, where does that fit in? I don't think it necessarily fits into any of those boxes. So there's already potential overlaps with existing international maritime conventions, which will apply in the event of accidents arising out of the operation of autonomous vessels at mass levels 3 and 4, which we won't see for a while, but we probably will be seeing by the end of this decade. Article 3 then goes on to define what is high risk, because it's high risk where they're proposing a strict liability system. It means a significant potential in an autonomously operating AI system to cause harm or damage to one or more persons in a manner that is random and goes beyond what can be reasonably expected. The significance of the potential depends on the interplay between the severity of the possible harm or damage, the degree of autonomy of decision-making, the likelihood that the risk materializes, and the manner and context in which the AI system is being used. And I think this potentially would cover the operation of unmanned ships at mass levels 3 and 4 when they are within the territory of the Union, in other words, the territorial sea of the coastal states of the EU. And also, even if they're outside that, if harm is suffered on the territory of the Union, supposing you're out at sea 150 miles away and you have an oil spill and it washes up on the coast of France. Sorry, but I keep referring to France as an example, and unfortunately France has suffered more than its fair share of pollution incidents. I think that again would be something which potentially would be falling within the proposed regulation. Then you've got some provisions on limitation of liability. A maximum amount of €2 million for death or harm to physical health or physical integrity of an affected person. So, you know, if you are having surgery and the robot surgeon chops the wrong arm off, the most you're going to get is €2 million under this, although presumably you can still try and claim in defect or negligence, depending on how the savings provision is construed. Doesn't seem a great deal to me, but and it's a smaller thing for significant immaterial harm. Yes, it's immaterial harm, so that's, you know, we're talking about non-physical harm that results in a verifiable economic loss or damage to property. That's just €1 million you get. AI systems are going to have to be listed in the annex to the regulation, and that's Article 4.2, and Article 4.5 says this regulation shall prevail over national liability regimes in the event of conflicting strict liability classification of AI systems. So it's the classification which is done by the regulation which wins out if there's a clash, and who's going to do the the listing, well, it's going to be done by the Commission. We've got some provisions about compulsory insurance. The front-end operator is going to ensure that the operations of that AI system are covered by liability insurance that is going to be adequate in relation to the compensation provided for in Articles 5 and 6. And then the back-end operator also has an obligation to ensure that its services are covered by business liability or product liability insurance that's adequate, again, in relation to those compensation amounts which are provided for in Articles 5 and 6. Limitation periods, quite a long one actually. Article 7 is a 30-year limitation period from the date the harm occurred, but only 10 years for economic loss claims. Now, if you are having AI operations which are not high risk, the Commission hasn't classified these operations as high risk, we can go over to a different regime, Article 8. The operator shall be subject to fault-based liability for any damage or harm that was caused by a physical virtual activity, device or process driven by the AI system. So if the Commission doesn't decide to put autonomous vessels into the annex for high-risk operations, they can still potentially be affected by the regulation with the fault regime which is then proposed in Article 8. So Article 8 then says there are some defences which show that the operator can prove the harm or damage was caused without his or her fault, relying on either of the following grounds. So you've got, first of all, the AI system is activated without his or her knowledge, while all reasonable and necessary measures to avoid such activation outside of the operator's control were taken, or you can show that you've had due diligence by performing these operations, selecting a suitable AI system for the right task and skills, putting the AI duly into operation, monitoring the activities, and maintaining the operational reliability by regularly installing all available updates. And then it says the operator shall not be able to escape liability by arguing that the harm or damage was caused by an autonomous activity, device or process driven by his or her AI system. And the operator shall not be liable if the harm or damage was caused by force majeure. So there's a sort of restriction here on the fault, the defence which is being proposed. However, there's also a fallback. If the harm or damage is caused by an interfering third party, which is modifying the functioning of the effects of the AI system, the operator is still going to be liable if the meddling evil third party is untraceable or impecunious. So if you get hacked and your system is modified and that then really results in damage, and we can't find the hacker, or if we do, he or she is impecunious, the operator is still going to have to pay up. Okay, is there a savings provision, rather like the sort of savings provision we saw with strict liability? There is a provision in relation to national provisions on compensation and the limitation period. Article 9 says civil liability claims which are brought under the fault regime of Article 8 shall be subject in relation to limitation periods as well as the amounts and the extent of compensation to the laws of the member state in which the harm or damage occurred. So national laws will govern those issues, although the basis of liability is going to be still that which is provided in Article 8 and with the permissible defences for the operator. So if autonomous ships don't go into the annex as high risk, they're going to potentially fall under Article 8. And there's a fault regime. That's the basis. Now that's clearly at odds with the Maritime Pollution Conventions, which are strict liability regimes. The CLC, Bunker Oil Pollution Convention, and the HNS Convention. Now there's some sort of mitigation in Article 9, which says, okay, we can limitation periods in quantum occur under the laws of the member state in which the harm or damage occurred. But the actual basis of liability is still that in Article 8. So there is a potential conflict there with the strict liability regime in those conventions. What would have been preferable, I think, for this proposed AI regulation is just to sort of completely keep away from it any claims arising under the Maritime Conventions. And that's what the Environmental Liability Directive did in 2004. And I think something like that ought to be go into this proposed regulation. I'd add in the Brussels Convention on Collisions 1910, and I'd add in the Hague-Bisbee rules and the Hamburg rules just for good order. Recent developments, and I'm talking about the developments which have happened really over the last couple of months. There's a report by CERRE, which is reported in March 2021. It says introducing a harmonized operator liability regime for AI systems may lead to delimitation. And I've been talking about some of the delimitation difficulties just now, particularly about the overlap with existing regimes, compensation regimes, which would apply to the operation of AI systems. And then it says, well, if we're going to have EU harmonization, here are 3 options. 1, a fault-based system with a higher duty of care. Then there's a fault-based system, number 2, with a rebuttable presumption of fault and/or causality link. And then thirdly, strict liability for high-risk systems. 21st of April 2021, the Commission itself has now published its quite a lengthy proposed regulation, and it's a regulation on actually regulating the use of AI systems within the European Union. There's virtually nothing on civil liability in that. But this is all going ahead on 3 fronts. You've got the regulatory aspect, which the Commission's published its proposed regulation very recently on that. You've got review of the Product Liability Directive, and then you've got this general proposal from the EU Parliament of a proposed civil liability regime. And it is not going to be restricted just to consumer matters like the existing Product Liability Directive. It's a general application. And I think the maritime community needs to keep an eye on this. It's not going to affect anybody at the moment because we don't actually have any autonomous vessels in operation. But over the next few years, that I think will change. And then we may find that unless this proposed regulation contains a carve-out in respect of existing conventions which deal with compensation as regards maritime incidents, we may then find that there is an uneasy interface between the 2 different compensation systems. So that's my second talk on what the EU's got up for its sleeve. The third talk, and the final one in this series, will be on what the EU is proposing by way of a directive to regulate human rights, liability and obligations on the part of businesses within the EU, something which is actually quite far-reaching. And I will be talking about that shortly. Anyway, thank you for your attention, and that next one will be along soon.